So clearly your customers have expectations about concerns about how to protect the security of their information, perhaps their business data. Regulators have clear expectations, of course. From the insurance perspective, there might be expectations of baseline security measures that you need. And what we're going to try to do with this panel is kind of define and clarify, hopefully, for you some of those expectations. And I think I got away ahead of myself to start with. My name is Jessie Ward. I work for NTCA, the Rural Broadband Association. We've got a great panel here today. I'm not going to introduce them with their bios. You can get those online. But just so you know who's going to be speaking today, we have Eric Pulse. He's the Director of Risk Advisory Services at Eide Bailey. Eric, wave here so people know who you are. There you go. Erin Fitzgerald is to his right. Erin is an associate with Bennet and Bennet. Robert Mayer, Vice President of Industry and State Affairs for U.S. Telecom Association. And finally, Travis Close, an account executive with Telecom Insurance Group.
Thank you, SDN, and for the opportunity to be here. And again, I'm with Eide Bailey, a regional CPA and consulting firm. And I've spent the last 20 years of my life dealing in frameworks, security frameworks, data security frameworks, all the way from FFIEC in the banking industry and HIPAA and healthcare, and FISMA with the federal governments, and working through NIST 853 and things like that. So I'm really excited about this particular framework. And you've heard it mentioned a number of times here today, or the last couple of days. I'm most excited about its voluntary nature. We could sit here and talk for the rest of the day about the pros and cons of regulation or not. But I would encourage anybody who is really pro-regulation to talk to the financial services industry, and we heard some references to that yesterday and even earlier today. Let me just say this: compliance does not equal security. When you have a framework or a standard or a set of standards that becomes a compliance mechanism, my belief is it ceases to be as valuable. This framework and its voluntary implementation, voluntary nature, helps you to really think outside the box as opposed to along the lines of a checklist. The previous session was phenomenal, and it gave you some very in-depth and personal perspective on how to walk through the framework. And so I'm just excited about this framework and the work that NIST is doing. And if you're not real familiar with NIST, they have a lot of information out there and a lot of different frameworks and standards and guidelines. So I would highly encourage you to, if you haven't peeled back the layers there with NIST specifically, please do so, because there's a lot of really great information out there. When I'm working with clients, and the clients that I typically work with today are small and medium-sized clients that typically don't have a lot of resources and monetarily, HR type resources to dedicate to IT and to security. And we help them through this sort of thing, right? Help them through these frameworks. And one of the first things that I ask them is, well, do you know where your data is? Because really, at the end of the day, it's about data. I want to talk a little bit here about culture. And I think that rises above everything, but at the end of the day, it's about data and protecting data. And if you don't know where that is, you don't know what to protect. We see breaches happening all the time, and those breaches expose really one thing, exposes data, right? And so at the end of the day, again, that's from my perspective, what this is all about, identifying where that data is. I mean, you can go on the, on the bowels of the deep dark net and find basically menus of what information, what data is worth, what somebody will pay for a US-based credit card number with CVV, what somebody will pay for a list of 30,000 email addresses. The emails that you get from all of your friends that say, pass this tidbit of information along to everybody in your contact list and you'll have good luck for the rest of the day. Basically somebody trying to compile a list of email addresses, right? Well, that email, those email addresses are worth something to somebody. And it's about, again, that data and that data having value. And when you think about the Target breach and their 90+ million accounts that were compromised, or the Anthem breach, 97 million policyholders' information that was breached, mine being one of them. Really, again, that data has value, right? And I've been in organizations that spend a lot of money on infrastructure and a lot of money on, monitoring devices and IAM and SIEM and DLP solutions and things like that. But if there's not an element of a secure culture in an organization, I'm going to slide into that right now. All of that means very little. Ask Anthem. I'm sure Anthem, I don't know how much they spend on technology, but I promise you it's a lot. Their breach was caused by somebody clicking on a phishing link. Somebody clicking on a link that they shouldn't have clicked on that allowed somebody in a backdoor or to create a backdoor and allow them in the organization. That's because there was a lack of security culture in the organization. We can talk about security awareness and training and things like that, but from my perspective, it's about a secure culture. And that culture starts really at the top of the organization. In this framework, it incorporates that. It incorporates the top of the organization all the way down. I used this analogy before, and it might be a bad analogy, but it helps me with some impact. When you think about September 11, 2001, and what happened on that day, the way we viewed something as simple as air travel, how we get on an airplane, that changed overnight. That changed in an instant. That whole culture, the way we view those things, changed dramatically. And we're living it today. But there are breaches that occur every single day, and millions of pieces of data are stolen every single day, identity stolen or whatever it is. And yet, I don't feel like, as a society, we've had that same cultural shift towards security and simply knowing what not to do. A couple of weeks ago, I received a telephone call from a small rural hospital. And the night before, the HR director received an email from the CFO requesting all of the employees' W-2 information. All the employees of the hospital and their W-2 information. So the HR person said, okay, it came from the CFO, I'll comply. Bundled up all the W-2 information and sent it on. Turns out it wasn't the CFO. The CFO's email had been spoofed and it ended up who knows where. I think they maybe traced it back to New Jersey somewhere. But again, I believe that just organizationally and societally and culturally, we have to have a shift. We have to have a shift in the way we think about very simple things. That HR person probably thought nothing of that request of the CFO, right? Maybe we need to start incorporating those outside of the box or kind of secondary sort of probing questions as to why does the CFO want this information? Maybe I need to pick up the telephone and ask them. And that's just that's an example. And that stuff happens every single day, all day long. And it's a scary thought. Lots and lots of organizations think they have a very secure environment, or relatively secure environment. It's built on nothing. That's where this framework comes into play. This framework is a fabulous framework for, in my opinion, building on that secure culture within organizations. And I'm a big fan of NIST, and I have been for many, many years. And we'll talk more, I guess, as we get into this about some of the industry impacts and things that we see. But I encourage everyone that I deal with on a very regular basis to consider this framework. Lots of organizations I work with are regulated. They're in the financial services sector. They're in healthcare. They have something, right, that they have to follow. And the great thing is this framework has been crosswalked or mapped to a lot of those other things too. So again, I appreciate the opportunity to be here and look forward to answering some questions.
Hi everybody, I'm Travis Close with Telcom Insurance Group. I handle South Dakota along with other states here in the Midwest. I'd like to just start off, and there's me a couple things I go back and forth with my questions. But the three main things I want you to think about throughout my presentation is how are you to minimize your risk or avoid it? Are your contracts in place, either with your hold harmless agreements, with your contractors you're working with, and also with your insurance? What do you have there if something does happen, even though you have everything correctly set up, just in case it does? My job here is hopefully, the end user, get you back to the point A where you started from. Like I said before, this is going to go back and forth with my questions, so I'll kind of skip through this. But this is about the target, which everyone's been talking about so far, about the 40 million credit cards compromised. Like we talked about before, it is different industry than yourself, but it is something. If Target's getting hacked, could it come to telcos, and they target telcos? That's why we have to, like everyone's here is, stay above and beyond those cyber threats. Here's again some other claims, examples from additional coverages. Client is sued, website publishing. People, especially small towns, rural telcos, they'll put up a picture of someone. Let's say someone's out in the ball field stands and they don't want to be that, or there was someone that shouldn't be. That is website publishing. They can get sued for being infringed on. Another thing, organization systems were hacked, which we're talking about right now, so we don't need to get into that. Breaches, yes. Like I said, everyone kind of looks at everyone coming in from cyber, from other continents, etc. What about your own employees? We all have trust in our own employees or laptop. Like for example, when everyone got up in here, there's a lot of laptops and phones there. What happens if that gets in the wrong hands? Like my laptop sitting back there, I use that as example. But what happens if someone steals that and my passwords, like we all see it, are taped up on my computer? There's a lot of employees out there that have it. I walk into it and see it all the time in different organizations. So that's one thing. We're all against, cyber threats are huge. We have to make sure that you don't have a disgruntled employee that really goes after you and sells that, I'm sure of which they could. So another thing to think of is employees. Hackers, we're not going to beat a dead horse here. Laptops stolen, it has a lot of information. Especially you got to make sure you have your care, custody, and control over your data. Here's the anatomy of a breach. The incident, employee theft, any of that nature, or like we've been talking about, the cyber. Discovery, usually it happens, later than everyone knows. Target as an example. Forensics, damage control, that's where the insurance kind of comes in. How do you get yourself back to point A? There's, example number 2 is website publishing. We will come in there and get that website, and there's a lot of costs that involved with that as well. So we're just, like I said, the insurance part is get you back to point A and develop what you need to have for coverages. Here's another thing I'm going to go back on later with the question, who is held accountable? The management is responsible, which we all know, which a lot of CFOs and CEOs are here. Another thing we need to take in is bring your tech. Your tech who's in charge, try to get them with you because they probably understand it a lot more than some other people. So get the most knowledgeable you can into your job and get them to help you out. The board, this is another thing I'll talk about later. Everyone thinks, what happens if like the board, like the Wyndham hotels, they were breached on multiple occasions. They're getting sued by shareholders because they did not do their due diligence to get back to where they should have. So they just sat there, they got hacked, well, we got hacked, we got insurance for that. Then they came back and did it again. Then that's when the board comes out, and that's usually out of pocket for the board expense up until your D&O retention, your deductible. So here's going back to my main thing, management of risk. What can you do? There's people, like great people here helping us out, trying to get us, so no one can hack into your system. What happens if they do? The FBI was hacked. Do you not think they have good safeguards and control? Again, it's a different spectrum, but it's something, even if you have the best IT out there, they still can hack into it. It just depends who's got the smarter guy it comes down to. Sadly, they're working on the opposite end of the system. Minimize, another thing right here is the transfer to a third party through insurance. The transfer is a key here, so it is all about how much retention. Also, another thing is with your contractors. Who has cleaning people come in? Is that contract correct? What if that cleaning person ends up being an IT person that can go in and hack your system? I'm sure it wouldn't take hard to go into some people's office and find some passwords. And that's pretty easy to do. So is that contract with that cleaning company correctly worded? And like little small things like that, you got to make sure the contracts are in place throughout all the industry. Retain is deductible. How much do you want to retain? Or deductible is another cost savings, or you can just retain it all. But what happens if they do eliminate, and I'll get further into that later. Here's the minimized controls. I won't go through these, they're just keeping things locked. We did have a couple of clients that had a bank. They bought a bank and they had a bank vault. So this happened years ago, but they came in there and they were just looking it over. The vault was unlocked. So what really good does a bank vault do if it's not locked? So, like I said, it goes back to care, custody, and control. Here's the cyber controls. This goes back to bringing it back to point A. You just want to make sure you got restore back to original. Make sure you take care of the people that you did harm, and there's a lot of fines and penalties as well. Here's the transfer of risks. This is what I'll be harping on the whole time. Insurance and the contracts. Data center, cloud providers, what if they get hacked? Do you have the right contract in place for them to be held accountable, or are they just going to, force it back to you? And we see contracts on the daily that are not in the telco or the company's favor. And so it goes back to them. So here goes back to security breach costs, restoration, what happens with your policy. Business income, like I said, I'll come back to this as well, so sorry to fly through it. Business income, extra expense, everyone has it on their current policy. But what if you don't have that cyber policy with this endorsement? Where are you covered? So that's a big thing. There's a lot of risk out there, and to be honest, the actual cyber policy is not that much for how much it covers for premium. So public relations, fines, penalties, and E&O, errors in mission. So that goes above and beyond a cyber policy, and that's another thing if something happens on the professional side that you'd get covered, but we're not going to hit on that today. So thank you, and I will look forward to questions.
So, you've got insurance and lawyers. We're really hitting all the big ones this morning. Sorry about that. So we're going to talk about FCC regulatory authority and FTC enforcement authority. Those are the two big agencies at play here. So for FCC regulatory authority, the FCC takes their authority from Section 222 of the Communications Act, which requires protection of customer information, okay? And that's for, those that are subject to FCC jurisdiction. Basically, until fairly recently, the FCC had looked at Section 222 authority as sort of just encompassing CPNI. And all of you know what that is. It's the sort of technical information associated with the work that you do, right? The FCC expanded its view of what is covered under Section 222 in 2014 during the Telecom Yortel data breach investigation. So basically, Telecom, and so we're going to talk about two sort of separate enforcement actions here by the FCC, and they're very different, and I'll explain why. Telecom and Yortel are wireless resellers, okay, and they're lifeline providers, and like all lifeline providers, they collected, qualification information from their subscribers to be sure that their subscribers were eligible for a lifeline. Unfortunately, they kept all of that information on a server that was, not password protected or encrypted and was connected to the internet. So that's problematic on any number of levels. The FCC investigated this situation and eventually brought an NAL against these two companies for $10.5 million. They eventually settled for $3.5 million, but that, up until this point, this was the largest privacy case the FCC had ever taken on. The point here really is that the FCC expanded its view of proprietary information under Section 222 to include all private information that customers have an interest in protecting from public exposure. So all of a sudden, there's just a larger amount of information that's subject to 222. The biggest takeaway here is that this was a pretty egregious violation, right? No password, no encryption, no nothing, all right? So this was perhaps not that surprising, aside from the fact that it was a very large enforcement action. The next case is not the same. Cox Communications had a breach. There was no technical failure. There was, they had protections in place, but in this case, hackers social engineered Cox employees to get information for about 61 of its subscribers out of over 6 million. Okay, so the percentage is very, very small. There was no evidence of consumer harm, and yet the settlement proposed was still very high. In addition to a nearly $600,000 fine, there were also extensive compliance measures. So this was a pretty big wake-up call. There have been several folks who've talked about the FCC's enforcement here being sort of a strict liability standard. And for those of you who are not lawyers in the room, God bless you, basically a strict liability standard is like, well, was there a breach? Okay, then you're going to pay. There's very little attention paid to the extenuating circumstances, and that's concerning for obvious reasons. So what does a company, when does a company deserve a fine or enforcement action? They tell you on the first day of law school that your best answer is it depends, and it comes into play here. That's absolutely the case. So often we talk about breach volume, how many individuals were affected, how much information was gathered, what the damages were. That sort of volume can impact enforcement. As we saw in the Cox case, though, it doesn't necessarily, okay? So I think, the industry is seeing this, enforcement should be driven by what sort of protections are in place. How much are these companies doing to try to prevent breaches? That may or may not be the case. So again, there's a sense that strict liability isn't really the greatest, stick to wield, if you will. These huge companies, Time Warner Cable, Sony, Target, the Office of Management and Budget, anyone else breached in that? Oh yeah, I was. We're seeing these huge entities that are getting breached, and so it's really proof that, no entity is safe, no matter what sort of protections you have in place. So rules of the road, see, we've been talking a lot the last couple days about how there are no checklists. As a lawyer, this makes me very uncomfortable. I like checklists a lot, but there isn't one yet. There is some insight, however. We do have some insight. The June 2015 Lifeline order provided us with some sort of basics going forward. The FCC said that in order to follow, 222, ETCs need to protect Lifeline eligibility documents by using firewalls and boundary protections, protective naming conventions, user authentication requirements, and usage restrictions, okay? So that's a start, and we're about to get some more. So the FCC has released a broadband privacy NPRM. We knew this was coming. NPRM, for those of you not in the know stands for Notice of Proposed Rulemaking. So you can see the 2015 Open Internet Order, or Net Neutrality Order, the FCC put broadband, made broadband subject to Title II authority, which makes it subject to Section 222 and the privacy requirements there. So I'll talk a little bit more about this in our What's Next section, but the NPRM was released early last month, and comments are due May 27th, so that's coming right up. So this is just very quick. We talk about enforcement and what the risks are. The FCC Enforcement Bureau has been incredibly active under Chairman Wheeler and under Bureau Chief Travis LeBlanc. So, you know, when we're talking about enforcement action risk, just know that, you know, this Enforcement Bureau has been busy. All right, this is going to be very quick. FTC enforcement authority stems from, you know, a different statutory authority, obviously, than the FCC. But they use enforcement authority rather than regulatory authority. So we're seeing cases being dealt with sort of on a case-by-case basis rather than promulgating rules and then enforcing rules based on what's been enforced. They're dealing with it much more on a case-by-case basis. And so he talked a little bit about the Wyndham case. The FTC brought you know, a case against Wyndham for their data breaches, and the Court of Appeals said the FTC could do that. They had the authority to regulate data security practices. However, there's a common carrier exemption in the statutory authority that the FTC has that says that the FTC doesn't have this authority over common carriers, okay? This wasn't a big deal until the Open Internet decision, wherein the FCC said, okay, broadband guys, you're now common carriers, or you're subject to, you know, Title II. So now all of a sudden the FTC's statutory authority to regulate you know, privacy and data breaches for common carriers is gone, putting it squarely into the hands of the FCC, okay? So that's where everything's a little bit in you know, shifting mode here, and we'll kind of have to see what happens. The FTC and the FCC have come up with a memo of understanding to try to figure out how they're going to deal with these sorts of things. Anecdotally, I can tell you that the FTC is none too pleased to have their jurisdiction curtailed in the way that it was. But this is all still sort of in the processes of being worked out. So like I said, it's sort of a question, FTC or FCC. Much of it will depend on what the courts decide. So what's next? Very quickly, enforcement action. You can see some various ideas here. All of this will be available to you in the slide presentation, so I'm going to go real quick. Breach volume is important. Whether the entity had breach prevention security measures in place is important. You know, I kind of say don't be a poster child. If you screw up once, okay, but make sure you don't do it again. Don't be that you know, kid that gets called on more than once. Nobody wants that. Okay, so the broadband privacy rules, I'm not going to go through these. It's a very long item. We could have an entire day session on that alone. My firm has put together a very comprehensive memo on this item. We recommend your participation in the proceeding, and so if you would like that memo, I'm happy to provide it to you. Just leave me a card. I'm sitting up front right here by the green cup. Okay? So basically it talks about transparency. It's really a matter of the FCC wants subscribers to be able to know what information is being collected and, you know, for what purpose, who that information is being shared with, and then they want customers to be able to opt out of that information sharing should they desire. It proposes some security requirements. It also proposes breach notification requirements, okay, which is new. And then there's choice involved in terms of allowing customers to decide who and when their information is shared with. Now, this is a huge item. I think it could really change the way that privacy is handled in your business. So do pay attention. This proceeding is a big deal, okay? Finally, so what's next? Use of the NIST framework. I haven't talked much about the NIST framework here, but this is not something that's going away. You're seeing agencies utilize the framework in ways that, you know, I think will continue. So we're seeing, you know, the CISRIC, you know, organization did their piece, which is fantastic. The compliance plan for Cox, that proceeding that we talked about, that enforcement proceeding, they required Cox in the compliance plan to use the NIST Cybersecurity Framework. So, I mean, the agencies are adopting it. And then finally, you know, in the broadband privacy program, you know, the FCC relied on some of NIST definitions and things like that. So this isn't going to go away. It's really important, and your attention to it now is excellent.
So U.S. Telecom, who Robert works for, and NTCA and other industry associations had really been working closely with another bureau at the FCC. So building off what Erin said, you had these enforcement actions that were happening, but at the same time, we were working with the FCC to try to come to an understanding about how cybersecurity would be regulated, or, you know, a new approach to regulation and the FCC's oversight. So Robert, with that in mind, can you talk a little bit about that approach, that industry collaboration, and how things have kind of shifted from that collaborative approach to now what we're seeing in the broadband privacy notice of proposed rulemaking?
Sure, and thank you again for inviting me. I think it was helpful that Erin laid out some of the aspects of the FCC broadband notice of proposed rulemaking. She said that there were some security requirements. I guess for this audience, I would say there are substantial security requirements, and they are potentially extremely onerous. So let me just start with that prelude now and go to a little bit to the prequel that leads up to that, so that I can explain where we are today in terms of our relationship with the FCC. There was a time when in Congress there were efforts to legislate cybersecurity legislation. And Erin, I think you may have been in that environment at that time, I'm not sure, when you were on the Hill, but two major initiatives. One, Collins-Lieberman, and another, Rockefeller-Snow, failed. Collins-Lieberman in particular would have set up DHS as a regulatory agency. Lieberman at the time was the chairman of the Senate Homeland Security. And industry was very opposed to both of those pieces of legislation. And at a time when there was a lot of partisanship in Washington, not that there is today, those legislative efforts failed. And what that left the Obama administration was with a problem, knowing that cybersecurity was becoming an increasingly visible because of the kinds of attacks that were occurring. Nothing was going to seem to be coming out of the Congress. So Executive Order 13696, I hope I had that right, 13696, yeah. Improving critical infrastructure cybersecurity was put out in February of 2013. And that set in motion a very significant trend away from a hardened prescriptive regulatory position to something that was more voluntary and flexible. It's embedded in the policy statements of that executive order. And one of the things they did was they gave NIST, I think it was 240 days, which is a very short period of time, to develop the framework, which they did. Just about that time, the FCC approached industry. They have the CISRA, Communication Security, Reliability, and Interoperability Council. It's been going on for years, and for many years they developed cybersecurity best practices. And the two prior cybersecurity best practices were very technical, very prescriptive, and we went to the FCC and we said, listen, this is not the time to start up another cybersecurity group. Why don't we wait till NIST finishes their effort? It's based on risk management, which we think is a more effective approach in terms of cybersecurity, and the FCC agreed. And on March of 2014, about 2 months, or one or 2 months after NIST delivered their version 1.0 of the framework, we convened the group, and we had over 100 people working, representing 5 industry segments: broadcast, cable, satellite, wireless, and wireline. And it took a year, and we came up with Working Group 4, which you heard about in the last couple of days. The significant thing that came out of Working Group 4 were 3 sets of assurances that industry agreed to the FCC. And frankly, even though we're a Federal Advisory Committee group, while we were developing this work, we were in consultation with the FCC, and we had to find kind of a balance between what industry would be willing to do, what the FCC would be willing to accept in this area. So we came up with 3 assurances. One of the assurances was that we would participate in C-Cube. which is part of the reason I'm talking on tomorrow on the panel. We've been very active. Jesse's organization has been active in participating in the voluntary outreach program. The second thing we agreed to was we would come up with industry metrics to somehow relate cybersecurity risk management to measurements. Well, we're going to be releasing a report in about 4 weeks. I will tell you that if there's any issue that is very, very complex and frustrates a lot of people, it's the issue of measurement and metrics for many reasons. I'll give you a simple example. You can say that, let's say you focus on malware and you see increases in it. Well, then they say, well, perhaps you're not successful because there have been this tremendous increase in malware. Well, maybe that's not the reason. Maybe you've just become more effective in detecting it and it gets reported. There are all kinds of counterfactual issues with measurements and metrics that I don't need to get into, but needless to say, we're still in discussions with the FCC on that point. And the third assurance, which leads me finally to the question, was where we agreed to have meetings with the FCC, one-on-one meetings between companies and FCC staff under several conditions. The most important condition was we wanted the meetings to be held in conjunction with the Department of Homeland Security, which is our sector-specific agency, and we wanted the protections that are afforded under a statutory provision under the Protected Critical Infrastructure Information Act, PCII. And one of the things about PCII is that when you are engaged with the government under the terms of PCII and you have an agreement with them, you have protections against state disclosure rules, FOIA protections, civil litigation, and most importantly, regulation. And the FCC accepted that assurance that we provided. We had a handshake on it, and we put it into the final report, and that's where we left Working Group 4 in March of 2015. From March 2015 to about February of this year, it took an extraordinarily long time for the FCC to draft a document called the Cybersecurity Policy Statement, which is now, for lack of a better word, languishing for 3 months on the 8th floor. The 8th floor is the term we use. That's where all the commissioners and their assistants are. We can speculate as to why it's languishing there, and I won't get into it. I mean, some people have ideas, others have, rumors. The bottom line is that cyber policy statement would have said, one, that the FCC is actively pursuing PCII, two, that since they can't get PCI, they were latching on to a term we put in our report which said PCII or a legally sustainable equivalent. They really don't have the ability to provide what I as a lawyer would describe as a legally sustainable equivalent, but in the document they came up with the next best thing where they talk about protections against enforcement and activities and other aspects which would give the assurance that they're not going to use it for regulatory purposes. So it's up there on the 8th floor. There were meetings with the commission offices. Our views on this were shared. We emphasized our interest in PCII. It's now 3 months later, and all of a sudden this NPRM on privacy comes out with the security provisions. And they start talking in that document about compliance regimes like HIPAA compliance and other authorities that are out there right now that are clearly compliance regimes. They talk about requirements for authentication regimes, all under what's called customer proprietary network information. Well, you think of customer information, it touches your entire enterprise. So the scope of the requirements that could be impacted as part of this order go to your entire enterprise systems. All of those systems that have information about your customers, about the products they have, personal information, billing information, it cuts through the whole system. If the more onerous aspects of that proposal get enacted, the next thing you're going to have is you're definitely going to have a standard of care. There's no question about it. You're going to have rules, And you're going to have the Enforcement Division, which is very aggressive, and Erin pointed out that just 2 of those actions, on our neck, just waiting for some evidence that all of these mandates in some way were not followed. That is going to impact every single telecom company, regulated telecom company in the United States, regardless of size. Those 2 firms that were hit with those big fines were not big companies. So we're at an inflection point in our relationship with our regulator at the federal level, where they have to decide whether they're going to go down the path that the chairman announced at the American Enterprise Institute in June of 2015, subsequently at other venues at RSA, talked about what he called the new paradigm, which was based on not regulating, because the FCC chairman recognized that regulation in cybersecurity is not going to work, but on industry demonstrating that it would, I don't want to say self-regulate because that's not a good word, but that we would be accountable, we understand the risks, and we would do everything we could to manage those risks. That was the path that we believed we were on up until this notice came out. So all I can say is that we don't know what direction this is going. This can either go in a good direction or this can go in a very bad direction. And all of us in Washington are working very hard on trying to have it the former as opposed to the latter.
Thanks, Robert. Unfortunately, we don't have too much time left, but I wanted to ask the question of all the panelists. There's a lot of talk in DC about standard of care, which of course has a very specific legal definition, but also just in general terms, is the framework becoming the new standard of care for your respective industry or stakeholder, whether that be insurance providers, the FCC or policymakers, or just the industry in general and your business customers? What are their expectations for use of the framework? And we'll start with Travis.
Well, technically for us, there is no new standard of care. There's new risks involved that we have to stay up and add them on, but the standard of care is always going to be the same. We just have to stay up with the new risks, like the new payment card industry, that the PCI, that's like new things we have to keep up on and keep up with our standard of care. So it's just an ongoing process.
I think the standard of care is perhaps strong. We're talking about this NPRM and what's been proposed. I think if that ends up being adopted, then that certainly becomes a standard of care. I certainly think the NIST framework is important, and the FCC has definitely shown its willingness to use parts of it and adopt parts of it and sort of incorporate it. But I think at this point, a standard of care for the NIST framework is a little strong.
I'll say this, coming from my position, I work in a lot of regulated industries, and as well as unregulated. But the framework, in my opinion, is we can use the term standard of care, but it's a great baseline for security. I'll be remiss if I didn't leave you at least with this. Well north of 90% of all breaches that occur happen because of vulnerability on a system. Define that, whatever it is. A vulnerability on a system was exploited, for which the CVE or the fix was readily available for over 1 year. So just let that seep in for a second. Well north of 90% of all breaches occur because somebody didn't apply simple patch management, right? And this framework provides for that, provides a foundation for that. If you don't have a process in place for simple patch management, well, this framework pushes you in that direction. There may be a lot of reasons for why you couldn't apply a particular patch to a device or a system. Maybe my third-party vendor says, can't do it because the application won't work on it, whatever it is. Then it becomes incumbent upon you to maybe put a little pressure on that vendor or whatever. But for organizations that that aren't regulated, they don't have any again standard to meet. This particular framework, in my opinion, is is a gold standard. One other quick thing about regulation. I'll yield back the mic, but there's a payment provider, a payment processor out there that labeled themselves as on the leading edge of security in the payment processing industry. Apparently, the CFPB, anybody know who the CFPB is? A Consumer Finance Protection Bureau. It's a relatively new agency, enforcement agency. Apparently, they didn't like the fact that this organization said we are on the leading edge of security, leading edge of the payment processing industry, because when they went in and they ran them through their their testing and whatever standard that they were holding them up to, turns out they weren't really better. They weren't better than anybody else. They were probably the same as most everybody else out there from a security perspective. Had some good things they were doing and maybe some bad things they were doing. They were levied a pretty hefty fine and now have to go through a lot of different hoops because of regulatory enforcement. So in an industry that's not heavily regulated in that regard, I hope it stays that way because when you have regulatory pressures and things like that, you don't tend to think again outside the box. You tend to think in terms of, do I have that in place, or do I have something that maybe provides for that? Check. What's next? So again, I think that this particular framework could indeed be that quote-unquote standard of care.
So quick point, NIST had a workshop, I guess a couple of weeks ago, and there was a panel from the financial sector, and I recall looking at the folks who were up on the dais. It probably was just a little bit bigger than this, and there were 8 people from different regulatory agencies for finance, and I said, oh my God, I mean, that's the nightmare scenario, right? So I guess in all things considered, we're in good shape. There was a lot of discussion when the framework was being developed as to how to characterize the effort made by an organization to apply the framework. And the word adoption was rejected because there was a big pushback from industry, because there was a fear that 5 functions, 22 subcategories, 22 categories, 98 subcategories, that adoption would be measured on the basis of what you've done in each one of these subcategories. And the word use was established, and we still use the word use to talk about implementation of the framework. So it allows people like Jeff England, who talked about, where you saw a very, very innovative application of using the framework to make decisions about which aspects of the framework were important to him. So I think NIST will continue to do everything in their power to avoid seeing the framework turned into a regulatory instrument or a standard of care, because they understand more than anybody that when it's constructed in a voluntary context, any effort to make it a standard of care is going to have a chilling effect, and all of a sudden you're going to have the lawyers involved, and it's just going to be a mess, and it won't be successful in achieving the aims that they want to achieve. So, but as Erin pointed out, if we get a regulator in our industry who mandates requirements, then it's game over. It's basically tilt for us, and we have to communicate that to the FCC in those comments, and hopefully be able to overcome what has been a 3-2 firewall at the commission voting level.
Good morning, Darren Carney, Utility Analyst at the South Dakota Public Utilities Commission. Throughout the past few days, we've heard that this NIST framework is voluntary, and it should be implemented as almost a best practice for a business in order to rein in on how well they're doing in cybersecurity and control. One thing that caught my attention when Erin was speaking was that the FCC ordered Cox to pursue the NIST framework in its compliance order. And so it seems to me that this could be used, or is starting to become a tool for regulators to use in a compliance type of situation. And the past talk throughout the day or throughout the past few days was that it's not intended to be used as a compliance tool. So I'm just wondering what industry's response was to that Cox order as far as mandating that they use the NIST framework.
I should probably clarify, that was part of the settlement agreement, so I'm not really sure that it could be legally classified as an order. And so presumably Cox agreed to do that. But yeah, I think that that is a concern in terms of, you know, how NIST has intended the framework to be used. And, you know, I think if you look at a regulatory agency, you know, voluntary things, that's not really their bag so much. So yeah, I think they absolutely, you know, in adopting it as something useful, I think they could turn it into something, you know, more mandatory, which I agree, it goes against sort of the original intent.
Robert talked a little bit about the cyber policy statement and the industry's collaborative work with the FCC to try to create this quote-unquote new paradigm where it's not a traditional compliance approach, where companies would have voluntary one-on-one meetings to talk about their risk management plan. That's historically where we were. And then, of course, Erin and Robert also talked about the broadband privacy notice and how that does have, unfortunately, a traditional compliance approach. Back even when we were talking about the cyber policy statement and those one-on-one meetings, NIST, I'm sorry, the FCC had said, when we want to talk to companies on a voluntary basis about their risk management plan, you don't have to use the NIST framework, but we're going to ask you what you do to identify, protect, detect, respond, and recover. So I was talking to one of our members, and he said, okay, so I got it. I don't have to learn German, but I have to talk in German. I was like, exactly. So, you know, we're seeing these references kind of seep in. You know, in the broadband privacy notice, the FCC is proposing that carriers look at risk management procedures to protect a whole realm of data in transit and data in storage. And to me, when you think risk management procedure for cybersecurity, even though they're not referencing the NIST framework, to me, the preeminent authority on cybersecurity risk management is the NIST framework. So to answer your question, I mean, it's not very clear, but to me, there's those underlying references, and we're really moving towards that compliance approach, unfortunately. You know, the associations, you know, Erin, you know, Bennet and Bennet, those of us in DC, we're doing our best to kind of head that off. And obviously NIST has been a huge ally in this process, talking about how voluntary is important. So I'm not a speaker, I shouldn't be talking so much, but
Can I make one?
yeah, sure, go ahead, Erin.
Just going back to the NPRM, you know, I know that, you know, US Telecom and TCA, the Broadband Association, you know, of which all of you are probably members, you know, will certainly be participating in that proceeding, and that's excellent. I encourage you as individual companies to also participate. You know, you can provide information, sort of compelling arguments that perhaps the associations can't in terms of the onerous requirements and what that means for your day-to-day business. And so, you know, I encourage you to look at the NPRM, think about it, and really take part in the proceeding. You know, this overarching argument of like, well, it's really expensive, that's not particularly compelling. But if you say, no, these 3 requirements are really problematic, and here's why, and here's how they impact, you know, our revenues, or, you know, here's what it's going to cost us, and this is why it's a problem, that becomes much more compelling. So we encourage you to take part and really, you know, talk to your associations, provide information as best you can, but also participate on your own if you have something substantive to contribute.
Any other questions? Okay, we're going to wrap things up. So before we do, one last question. We got 3 more minutes. Any final thoughts? What would you most like the audience to take away? And we're going to go down the table and start with Travis.
Okay, like I said before, the biggest thing on the insurance side is the contracts, you know, transfer of risk between insurance and your, you know, contractors you work with, and minimize or avoid any kind of cyber threats. The best is, you know, do your due diligence, make sure you're covered, and then have, you know, escape routes if something were to happen. Big quote here, in short, insurance keeps a small business operating when the worst case scenario happens. So like all insurance, you want to get, you know, pay premium to get back if the worst case scenario, terrible cyber threat was to occur, to get you back to point A so you can continue doing business and continue making, you know, money and providing telecommunications services.
I just gave you my takeaway about 2 minutes ago, so I'm going to pass the mic.
No, good call. again, thanks for the opportunity to be here. But I think a takeaway from my perspective here is, again, this NIST cybersecurity framework is, I mean, it's a fabulous foundation for any sort of, security risk assessment, IT security assessment. Throw whatever term you want to in there, but it's a fabulous foundation for that. I mean, it provides a means to the end of again, risk management and ultimately risk mitigation. Kind of a side note, I feel like some of the industries have missed an opportunity. The financial industry created its own cybersecurity assessment tool. I would have loved to see them utilize this particular framework, and we have healthcare and others, NERC and those sort of things that are throwing things out there. But I'm not an attorney. I don't know the technical definition of standard of care, but I would love to see this particular framework move forward in that regard, along all industry lines for, again, securing infrastructure.
Yeah, keep it real simple. I would say hope for the best, prepare for the worst. You have to, I think, in this environment, assume that over time, not only at the federal level, I know that the commissioner from the South Dakota Public Service Commission is here, chairman of the Telecom Committee. They're 50 states. They have a very legitimate interest in this area. The risk is that we could have a very balkanized set of oversight over time if the states also get involved in requirements. We've been so far, I think, largely very successful in working with the states through the National Association of Regulatory Utility Commissioners to try to rationalize state and federal activity in this area. But I think if you're not anticipating a more prescriptive regime over the next few years, you're probably not doing the proper due diligence within your organizations. And if it's not regulation, you can be sure it's going to be legal liabilities and exposure.
Okay, let's give a big hand to our panel.